Anyone who attempts to travel to Australia by boat without a visa will be turned back or transferred to a regional processing country. The following information is not for people whose protection claims are being assessed in regional processing countries. This information is for people who arrived in Australia by boat without a visa on or after 13 August 2012 and before 1 January 2014 and whose protection claims will be assessed in Australia. The Australian government has started to invite people in Australia who arrived illegally by boat to apply for a protection visa. People must wait to receive an invitation before applying. There are many people who need to apply. It will take a long time to process them all. You need to be patient and wait for your invitation. While you wait for your invitation, there are some things you can do to prepare. Make sure the Immigration Department has your current address and other contact details. To update your contact details, call 1300 728 662. With your name, date of birth, boat identification number, home address, and contact phone number. You can collect the documents and information you will need for when it is your turn to apply. This includes original genuine evidence of your identity, nationality, and citizenship, which could include identity and travel documents. You should also collect information and evidence to support your claims for protection. To help you understand the protection visa application process, there are translated guides on the department's website. You should look at the guides before you are invited to apply so you are ready when it's your turn. You can find them at www.border.gov.au/PAIG. If you want to hire a registered migration agent to help you, you can do so at your own cost. If you do hire a registered migration agent, let the Immigration Department know so they can contact you through that agent. When it's your turn, the Immigration Department will send you or your agent an invitation to apply for a visa. As you arrived illegally, you can only apply for a temporary protection visa or a safe haven enterprise visa. You should consider which type of temporary visa is best for you. You can find more information about these visa options at www.border.gov.au/IMA. When you apply for a protection visa, it is very important to give the Immigration Department all your protection claims and supporting evidence early and in full. If you do not do this and your application is refused, you will probably not have an opportunity to provide any new claims or new evidence. The Immigration Department will consider your application and ask you to come to an interview to discuss your application and claims for protection. After the interview, a departmental officer will fully assess all your claims and evidence and make a decision on whether or not you engage Australia's protection obligations. If you are found to engage Australia's protection obligations and meet all other requirements like health, security, character and identity checks, you will be granted a visa. If you are found not to engage Australia's protection obligations, your application will be refused. You will be expected to depart Australia. Visit the Immigration Department's web pages for up-to-date information about the protection visa application process.
Up! Up! Up!
Outdoors, indoors, day or night. The Task Force leader Rakistan Guardian Angels train and prepare for force protection threats in eastern Afghanistan. The GAs are mentored by their platoon leadership and a Polish officer named Wallace.
We conducted tactical training with the GA platoon, focusing on urban area. So the first thing, we started like basic training with radio ops drills and tactical movement in an urban area around the buildings and how to approach the building, which is a target sometimes, and clear the building and give us security for the advisors which works inside.
Red!
When we met Wallace, we realized that he had a lot of things to offer. I asked him if he could start conducting training at the lowest level and then building up to squad-shaped movements and squad-shaped battle drills, and entering clear buildings, and numerous amount of other things to include the VIP escort missions that we do.
We have somebody with him that is willing to take a lot of his own free time and come and train with us and teach us new things or refine old skills.
I would turn him like this instead of like standing.
Wallace is probably the most interesting person that I've ever met. He is so unbelievably outgoing and so energetic when it comes to the training. He's been the most inspirational, the most motivating guy that I've ever worked with.
This kind of training gives me, build a very, very good relationship between two our countries, so we can pretty much share the knowledge, the military knowledge, but the culture, our country culture too. So I'm very, very pleased of working with your guys. I can see everybody got very good ability, and everybody got pretty much very good attitude for the training. So pretty much I can say in a short way, people like to train, soldiers love to train. More sweat during training, less blood on action.
From Afghanistan, Captain Charlie Emmons, TAC East Public Affairs.
A Plaintiff's Guide to Protection from Abuse Cases in Maine. Getting help with the court process.
Hello, I'm an attorney at Pine Tree Legal Assistance. I help victims of domestic violence when they are asking the court for orders of protection. If you've decided to file a complaint to get an order of protection, you may be able to get help from your local domestic violence agency. They can help you fill out the paperwork, explain to you what will happen in court, and help you make a safety plan. You can get contact information about your local domestic violence agency from the clerk at the court or from the Pine Tree Legal Assistance website.
Representatives from your local domestic violence agency can help you file a complaint with the court. To locate a domestic violence agency, call the statewide domestic violence hotline 1-866-834-HELP. Use this link to find a local helpline number. Or ask your circuit court clerk or Pine Tree Legal Assistance for a referral. Filling out the complaint form.
If you are the plaintiff and have decided to fill out a complaint, there's a section where you have to write down what's happened to you and why you need protection. Start by putting down what your relationship with the defendant is or was. Are you married? Are you partners? Were you living together, or did you have a child together? Or were you in a sexual relationship? Then write down the incident that led you to ask for protection. Describe what happened. Don't just put that you were physically abused or threatened. Be specific. If you were hit or slapped or pushed up against the wall or forced to do something against your will, if you were prevented from leaving or prevented from asking for help, write that down. Then put down if you've ever been abused by this person in the past. If you were physically abused or threatened, you can write that down, but then give some examples, either of the worst thing that happened or the most dangerous time that you can remember. If the defendant has been arrested for hurting you, write that down as well. If your children have ever been abused or were present during the abuse, put that down and give some examples. You don't have to write down every detail of your relationship. For some people, a paragraph will do. Some people may have to add 1 or 2 pages. The important thing is to be clear and be specific so the judge can understand what happened to you and why you're asking for protection.
As you fill out the complaint form, describe your relationship with the defendant. Be clear and be specific about what happened to you. Let the court know if your children witnessed the abuse, or if the defendant has abused the children. Let the court know if the defendant has a history of hurting you. What to do if you are not granted a temporary order of protection?
If you are not granted or do not ask for a temporary order of protection, you will still be given a hearing date within 3 weeks when you can come back to the court and ask for a long-term order. If you do not get a temporary order of protection, the responsibility of making sure that the defendant is served with your complaint and with notice of the hearing is your responsibility. To do this, you have to go to your local sheriff's office and give them the paperwork. You have to ask them to serve the paperwork on the defendant. Once the sheriffs have served the defendant, they will sign a piece of paper saying that the service has been made. Some sheriff's office will return this directly to the court. Others will return it to you. You should ask the sheriff what will happen with this signed paperwork saying that the defendant has been served. You have to make sure that this paperwork gets back to the court. The court has to know that the defendant has been served, and they have to know that in writing.
If you do not receive a temporary order of protection, it is your responsibility to bring the court paperwork to your local sheriff's office so they can serve it on the defendant. Make sure that the court receives written confirmation that the defendant has been served. The final order of protection.
Whether the final order is agreed to or granted after a hearing, the judge will want to make sure that the plaintiff is properly protected, and some plaintiffs may want to have no more contact with the defendant. However, a final order can be written to take into account a particular situation. For example, if the plaintiff and defendant are married, the order can provide for visitation, safe drop-off and pickup, and contact, perhaps phone contact, between the parties so that they can talk about the children. The order can also provide for child support and some division of personal property. The final order can last for up to 2 years, and if circumstances change during that time, either the plaintiff or the defendant can ask the court to modify or change the order in writing.
The order of protection can be written to meet the needs of your specific situation. It can provide for child support and some temporary division of personal property. It can last for up to 2 years. Either the plaintiff or the defendant can ask the court to modify the order if the situation changes. Criminal charges against the defendant.
If the defendant has been arrested, there may be criminal charges pending. These charges are brought by the state of Maine and are prosecuted by the DA. The plaintiff may be a witness in this case, but the plaintiff is not bringing those charges. The protection order is a civil case. The plaintiff brings it in civil court. The judge in the protection order hearing may not know that there are criminal charges pending against the defendant. You should tell the judge. If the defendant has bail conditions that allow for no contact between the defendant and the plaintiff, and there's a protection order that allows for some contact, for example, phone contact, that contact cannot happen until the defendant's bail conditions have either ended or been changed.
You should tell the judge if the defendant has been arrested or is subject to criminal charges, or if the defendant is subject to any bail conditions that might affect your protection order.